Come on, Greg. Shared with the attorneys, the jury's indicated they're deadlocked. And so the request has been made by the state for now in charge. Is that correct?
Yes, sir.
Very well. Let's bring in our jury, please. Another note?
He just, the person who gave it to me before he called it.
Yeah.
Well, they can do that with text messages. Isn't evidence just goes to the sheets? I don't understand. So they're saying.
Okay. You all right with that? Yes. All right. That'll be Court's Exhibit 7.
Do you want this back? Or?
Please. Thank you. Okay, we ready? We ready?
Yes, sir.
Yes, sir.
Please, Bobby, if you will assist us, please. Thank you very much, ladies and gentlemen. I received, Mr. Lang received Court's Exhibit 6 now about the time that lunch was coming, and that's why we delayed bringing you in. Thank you for 6, and since that I've also received Court 7. I'm going to deal with Court 6 first, and then I'm going to address Court 7, your last inquiry. According to Court 6, you've indicated, Mr. Langdon, the jury's deadlocked, and there's been a request that I give some further instruction, and if I could have your attention, I'd like to give you some additional instruction to couple with that which we have previously given to you. You as jurors and as judges are not called upon to decide cases very much, and we talked about that. I think I mentioned that to you. My job, on the other hand, puts me in court where I try cases day after day and throughout the year. And I can tell you that it's very unusual for a jury to go out and return immediately with a verdict. However, we usually get a verdict. What that means is this: it's normal for jurors to disagree at first, but the fact that we normally get a verdict also means that after reasonable persons lay aside all extraneous matters and determine to decide a case on the basis of the law and the evidence, then they do come to a common understanding and write a verdict. It has never been in this process the intention of a verdict to be that of one person. On the other hand, the verdict of a jury is the collective reasoning of all 12 persons. The reason we have a jury is so that we may have the benefit of the collective thought and reasoning of each individual juror. It may help to tell other jurors how you feel about the case, and I'm sure you've already done that to a large extent. And I'm not suggesting that you haven't. On the other hand, it may help if other jurors exchange views with you. And I ask that you listen to each other, and I'm sure you've done that, but I'm going to ask you to revisit that again. And to give deference to each side, and to be willing to compare and consider what one is saying that may disagree with your respective positions. I say that for this reason. A mistrial is a very unfortunate thing. If you as jurors cannot agree upon a verdict, it doesn't mean that anybody wins or that the case is over. It simply means that at some future time, at another term of court, that another jury will sit where you are. And in the trial of the case, the same participants will come in, the same lawyers will likely appear, the same questions will be asked, and will presumably get the same answers. We'll go through this entire process again. There's no reason for me to believe, to suppose that a more or clearer evidence will be produced by one side or the other. And I have no reason to believe that the case will ever be submitted to 12 people who are more intelligent, more impartial, or more competent to decide this case than you are. One day this matter will be decided. And we are all aware that it's legally permissible for a jury to disagree about what the facts of a case may truly be, or what the verdict should be. Obviously, there is nothing upon which you can disagree about the law. The law is, as I've stated it to you, and which has been provided to you. If you have a disagreement about the law, I should clarify that for you. But if you disagree over what you believe the evidence has shown, then only you can resolve that conflict. If it is to be resolved, I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room. Again, taking turns to tell each other, jurors, the weakness of your position and listening to the strengths of theirs. You should not interrupt each other or comment on each other's views until one has had a full chance to talk. During this process, the course of your deliberations, each of you should not hesitate to re-examine your own views and to change your opinion if you're convinced it's erroneous. Each juror who finds himself or herself to be in the minority should reconsider his or her views in light of the opinions of the jurors in the majority. Conversely, each juror finding himself or herself in the majority should give equal consideration to the views of the minority. No juror, however, should surrender his or her honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors, or for the mere purpose of returning a verdict. But remember also that after full deliberation and consideration of the evidence, it is your duty to agree upon a verdict if you can do so without disobeying your individual judgment and conscience. Now, with this added instruction, I'm going to request that you retire to the jury room and deliberate further. In that regard, Court's Exhibit 7, and this is one of those things that is not uncommon for this to happen. You're trying, and I appreciate your diligence in trying to understand and comprehend and relate evidentiary matters. But the law doesn't allow us to comment to you in resolving the factual disputes or understanding. You have to do that. And now there are ways to do this. I've asked the attorneys, and they've agreed that I can give you this much. I don't want to know what you shouldn't tell me. I don't want you to tell me what the concern is about Court's Exhibit 7. I will tell you that we know that there's testimony that different companies use different time zones. One used Eastern Standard Time, the other used Pacific Time. Don't know how that relates or whether that helps or hurts. But if you can't resolve it, remember, just tell me the witness or witnesses you need to rehear, and we'll be happy to play that testimony for you, and they will answer your concerns or questions concerning this particular item of evidence. But thank you very much. With that instruction, I ask you to retire and resume your deliberation. Exceptions, additions from the state?
No, sir.
Exceptions, additions from defendant?
No, Your Honor.
Thank you very much. We'll be at ease again. Stay, in case they send me, they want to hear testimony, stay reasonably close. Thank you very much. But those in the audience, if you need to step out, don't worry. We'll bring you back.